Secretary Ross, you asked for a memo on the citizenship question from your Office of General Counsel, and you got it back from James Uthmeyer on August 11th, 2017. What did that memo say?
We've produced some 8,700 documents here, and I gather there are some more that the committee may wish to see.
Okay, so you're willing to produce that memo then too?
I'm sorry, I didn't hear the question, sir.
But are you willing to produce that memo that was written to you by James Uthmeyer about precisely what we're investigating here today, the citizenship question?
I will take it up with staff and with counsel following this hearing, and we will get...
Well, you know, I've seen from the record that you're quite effective at getting your staff to do things. For example, moving on the citizenship question, will you tell them to turn this memo, which deals precisely with what we're investigating, over to the Congress of the United States?
I will be delighted to take it up with my staff after the hearing, and we will consult with counsel, and they will give you a response.
Okay, well, I understood your testimony before to be that you would refuse to turn it over on the grounds that there's ongoing litigation, and we just heard that argument echoed by the gentleman from North Dakota. And I must say, Mr. Chairman, I'm quite astounded by this line of argumentation today by our colleagues. To begin with, the Supreme Court has been perfectly clear in a series of cases, including Hutchison versus United States in 1962 and Sinclair versus United States in 1929, that the fact of ongoing litigation is not a valid grounds for withholding documents from Congress. Are you aware of that, Secretary Ross?
That requires a legal opinion, sir. I will have to refer that to...
Okay, well, that principle goes back at least 90 years, and we can give you countless examples of investigations by both Republican and Democratic chairmen of this committee, as well as dozens of other committees in Congress that have conducted investigation and received documents while there was ongoing litigation. For example, Chairman Chaffetz had a hearing on the waters of the United States EPA rule when it was still being litigated and got documents there. So he did the same thing in the Keystone XL pipeline hearings when there was ongoing litigation, and Chairman Chaffetz did the exact same thing with the Equifax data. So you are not a lawyer. You may not be aware of Congress's power to obtain documents, including this so-called secret memo, which is being withheld now. But our colleagues certainly should be perfectly aware of that fact, and the representative from the District of Columbia is perfectly right, of course. The Supreme Court is limited to review of those facts that are on the record of the case, all the more so in an appeal from an Administrative Procedure Act decision, right, where everything is in the administrative law record. That record also was very clear about what you had done. That record said that your decision to add the citizenship question was arbitrary and capricious, that you violated the law, that you violated the public trust, that your stated rationale to promote Voting Rights Act enforcement was pretextual, a veritable smorgasbord of classic clear-cut APA violations. But you are aware that when the Supreme Court treats this matter, it's going to treat it as a matter of fact on the four corners of the administrative law record. Are you not?
That's a very lengthy question, sir. I think it calls more for a legal opinion than my opinion. I'll be happy to...
Okay, well, your decision was also struck down on the basis of the enumerations clause, so it was constitutional as well. Is there anything that you would tell us that would somehow alter the Supreme Court's interpretation of whether or not your judgment to add the citizenship question is constitutional?
I don't quite understand the question, sir. Could you repeat it?
Okay, let me ask you this. The California District Court said what ensued was a cynical search to find some reason, any reason, or an agency request to justify a preordained result. So let's just put it in very simple terms. I'm not going to ask you about the law. Obviously, you don't want to talk about the law, and that's fair enough. Did you not have a search? They describe it as cynical, but whether or not it was cynical, did you not have a search to get to a preordained result? Wasn't the whole purpose to get the citizenship question added regardless of what was found in the administrative law process?
The rationale for my decision is encompassed in the March 26, 2018 decision memo. That's the basis on which the decision